Thank you, Mr. Speaker, and I want to begin by thanking my colleague, the Honourable Member for Thunder Bay Superior North, for seconding these motions. As the House will know, this legislation was brought forward in place of, at least after Bill C-30 was withdrawn, the so-called Protecting Children from Internet Predators Act. We have this legislation brought forward, and I do understand the reasons for urgency. This legislation, Bill C-55, is in direct response to a decision of the Supreme Court of Canada in R versus Say, in which the court found that the current emergency wiretap provisions failed the charter test, but the court suspended its ruling for 12 months to allow this House to remedy those sections of the criminal code such that they would conform with the charter. Of course, the clock started ticking when the Supreme Court rendered its decision, which was April 13th of last year. So we have a small amount of time, Mr. Speaker, to correct those mistakes. So I want to start my discussion of the amendments I'm putting forward by stressing that I also support Bill C-55. It is overall well-crafted and meets the challenge of ensuring that this extraordinary power of the state to obtain emergency wiretaps without a warrant, and this is what we're talking about, is that a really quite egregious invasion of privacy of the individual citizen is balanced and only justified in exigent circumstances when certain standards have been met, and that it's only charter compliant, according to the Supreme Court decision in R versus Say, if there are adequate oversight mechanisms put in place. So my amendments, Mr. Speaker, go directly to the point that we don't want C-55 to be struck down by a future court because we failed to put in place the adequate oversight provisions. We failed to get the balance just right based on the advice of the Supreme Court. So I'm just going to take a moment to go back to the ways in which the Supreme Court of Canada's decisions around these matters have evolved in very recent years. It wasn't long ago, Mr. Speaker, that our major authority, the precedent from the Supreme Court of Canada that governed in this area, was a 1990 case, R versus Duarte, in which Mr. Justice Laforêt found that, quote, as a general proposition, surreptitious electronic surveillance of the individual by an agency of the state constitutes an unreasonable search or seizure under Section 8 of the Charter. So it takes quite a bit of evolution within court decisions to say, well, how do we justify Section 183 and 184 of the Criminal Code in allowing the state, without access to a warrant or even a judicial review of any kind, to go forward and wiretap private communications. That process is now settled in a new precedent of the Supreme Court of Canada in R versus Say, in which the court ruled in the majority that, yes, in these exigent circumstances where, for instance, there's a kidnapping or other criminal event where a life is at stake, and that there really legitimately isn't time to get to a court for, to get to a judge for a warrant, that's now going to be acceptable under the Charter. But what's not acceptable under the Charter, Mr. Speaker, is when these powers are not adequately supervised. So I think that needs to be a foundational point that is stressed here. These are intrusions into the private lives of Canadians that in any other circumstance would be viewed as Charter violations. And this House must craft very carefully that rare exception when we're going to let the state intrude on our personal communications. I'm troubled, Mr. Speaker, sometimes when I hear the comment, well, why would we worry if people want to wiretap criminals? The only people who'd be worried about that would be people who have something to hide. I think we need in this country to constantly remind ourselves why we prize the Charter of Rights and Freedoms, and before the Charter of Rights and Freedoms, why Western democracies, why the British Empire, why our common law, why centuries of practice and respect for the rule of law recognize that the state has no business knocking down your door, and that if we don't I mean, literally pushing your door without you breaking through your house and invading your privacy, which in an electronic era includes wiretapping. We have to remind ourselves why civil liberties matter. We have to remind ourselves of this fairly constantly, because not just in this kind of instance, but through other laws passed through this place, we are seeing an erosion of our respect for the idea of civil liberties through resort to such rhetoric as, well, only criminals need to worry, and we shouldn't be so worried about criminals as we should be about victims. A victim of an injustice of the state invading our civil liberties is no less a victim than the person mugged on the street. We need to pay attention to civil liberties. That's why I'm putting forward my amendments, Mr. Speaker. Now, the court ruled very clearly in R versus Say that the failure of the current criminal code provisions was in a failure to have adequate accountability measures. Now, the court didn't set out what the accountability measures should look like with any degree of specificity. So Bill C-55 attempts to, and does, put forward accountability measures, but will they pass the charter test in a future Supreme Court case? My submission to the House, and I urge other members to vote with me, is we make this bill much safer and more secure against being struck down later by improving the accountability measures. The amendments I put forward would ensure, for instance, that the intercepted communications would have to be, there'd be an Attorney General report which would include records of all those wiretaps for which no charges were ever laid, would include memorializing. The police officer in question should memorialize the reasonable grounds that they had at the time for seeking warrantless wiretap evidence, that we record and report as much information as possible to ensure that the oversight regulatory process, the oversight statutory process in Bill C-55 meets any future charter challenge. And for those, Mr. Speaker, my amendments are based on recommendations primarily from three groups that testified before the Justice Committee: the Canadian Bar Association, the British Columbia Civil Liberties Association, and also the Criminal Lawyers Association. Those three bodies recommended, in the language I have used, the amendments I am putting forward today. They strive to ensure that there be a requirement, for instance, that publicly report the numbers of persons whose communications were intercepted but who were not subsequently charged. They include, as I mentioned, the police officer's justification for the interception to be recorded and memorialized, and that we also ensure that if subsequent judicial authorizations are obtained on the same grounds as of the interception under Section 184.4 of the Criminal Code, evidence obtained by the further a 184.4 interception could be ruled, may be ruled inadmissible. Now, the other piece that I just want to mention briefly is something that wasn't part of the res judicata of RSA, but certainly was significant obiter dicta, and that was the court's concern that the definition of peace officer was overly broad. The court found, and I cite the majority, well, there wasn't a dissent, the decision of the court on this matter, and they noted that they would agree, this is at paragraph 57 of R versus Say, we too have reservations about the wide range of people who, by virtue of the broad definition of peace officer, can invoke extraordinary measures permitted under Section 184.4. That provision may be constitutionally vulnerable for that reason. Now, I'm not saying that the Justice Minister hasn't taken account of this obiter dicta. The revised Bill C-55 no longer uses the term peace officer. The revised Bill C-55 in Section 2 changes the term peace officer, which was overly broad. It can include anything from mayors and reeves and so on, to police officer, but then in the definition adds an element of overly broad definition by saying police officer means any officer, constable, or other person employed for the preservation and maintenance of the public peace. I remain concerned, despite the quite interesting testimony, and I thank the Justice Critic for the official opposition who pursued this point with the Minister of Justice. I am less sanguine about leaving in the term or other person. So one of my amendments would remove the term or other person to further clarify the Act and ensure that it is not constitutionally vulnerable. So, Mr. Speaker, I just conclude by saying my amendments come forward in the interests of ensuring Bill C-55 will survive any future charter challenge, and I recommend them to my colleagues. Thank you.